Herzlich willkommen zum Jean Monnet Podcast der Martin-Luther-Universität Halle-Wittenberg. Welcome to the Jean Monnet Podcast of the University Halle.
The legal regulation of water in Ecuador, Colombia, and Chile has a common origin. Andrés Bello, a prominent Venezuelan jurist, commissioned by the Republic of Chile, was the first to produce a civil code in the region in 1857. The legal framework regarding water was initially replicated almost entirely in Ecuador and in Colombia. Consequently, the starting point for the three national water legislation is the same. In Chapter 3, entitled Of National Property, the Chilean Code established that the adjacent sea, major rivers, and major lakes were public property. Subsequently, the characteristic of a major river corresponded to those waters that flowed through natural channels in all seasons and carried the water immediately or through other rivers to the sea or major lakes. Minor rivers were those that dried up in some seasons, or even if they were perennial, flowed into smaller lakes. Major lakes were then those whose shores belonged to several owners, could be navigated by ships of more than 30 tons. Lakes that did not meet these conditions were minor. Minor rivers, minor lakes were susceptible to private ownership. How can we explain on these days such regulation? Within the framework of the 19th century Latin American states were then beginning to build and improve the roads through which they could connect with the world through the export and import of goods. It is very suggestive that the initial regulations of water addressed criteria such as the permanence of the channel in different climatic seasons, the interconnection of rivers with the sea, and the possibility that ships of 30 or more tons would navigate. This type of regulatory approach was not extraordinary. On the contrary, they could easily be framed in the context of modern state administration. The schematic simplification has been an effective form of legibility for the art of government. However, this tunnel vision, this narrow frame of reference, has often left out relevant variables and factors that generated harmful consequences. Colombia, utilitarian conservation, sustainable development, and participation in judicial decisions. The emergence of Colombian environmental legislation was the result of the country's presence in the first Earth Summit held in Stockholm in 1972. As a consequence of the conference, Colombia produced the first framework law in environmental matters in Latin America. A general analysis of this first law reveals a utilitarian approach to water as a resource. The state's purpose was to regulate how private individuals access the resource rather than adopting an ecosystem approach. A list of the titles in the section of law that regulate water can shed light on this statement. I quote, on dams, on transporting water and watering livestock, on the use of riverbanks, on hydraulic works, on mining uses, on the use of rainwater, end of quote. The main problem with this approach is that it ignored the ecosystem reality of water and regulates it in only one dimension and for the benefit of single humans. The argument that our abuse of nature undermines the material condition for our own survival although true, assumes that our concern for nature is based on self-interest rather than on a sense of belonging to the community of life. Later, in 1993, the ideas and proposals put forward for Rio 92 had a significant influence on the constitutional environmental Colombia laws. Thus, the current water law in Colombia is primarily composed by the pragmatic rules of the Civil Code of 1887, those from 1972 with their utilitarian approach, and those from 1983 framed with the sustainable development. Additionally, in recent years, multiple judges have ruled that some rivers have rights. The first ruling was the T622 judgment of the Constitutional Court in 2016, followed by many others decisions. In none of these cases were the rights of the rivers clearly defined. On August 8, 2024, the Congress of the Republic of Colombia approved Law 2450 of 2024, which declared the Rancheria River a subject of rights. Moreover, the existing legislation has proven to be highly ineffective. In 2007, Decree 1575 was enacted, a regulation that governs the sanitary surveillance of water quality for human consumption. 14 years after the decree was issued, it was reported by the government that such surveillance has yet to be produced. On the other hand, the Colombian Academy of Natural Sciences recently published a research study on the Magdalena River, a basin where 77% of the Colombian population resides, and the researchers identified that nearly 78% of the Magdalena River exhibits critical erosion, and that in addition, there has been a 62.5% reduction in fish volume over the past 40 years. The river also suffers from abundant contamination from solid waste, metals, fertilizers, and domestic waste. To conclude this chapter, one of the most important challenges, while political peace accords have been signed with some armed groups, the enduring armed conflict in Colombia continues to impede scientific field research, undermine community participation in water governance, and erode the efficacy of law. The limited state presence in conflict-affected areas exacerbates these challenges, leaving local communities particularly vulnerable to the consequences of weak governance and environmental degradation. This represents probably the most substantial, intricate challenge Colombia faces in the endeavor to effectively manage and safeguard its aquatic ecosystems. This is the Magdalena River. Now, Ecuador, nationalism, reivindication of ancestral borders, and ecocentrism. In 1970, the nationalist revolutionary military movement deposed President Velasco Ibarra from power and appointed General Rodriguez. He enacted the Water Law of 1972, which marked a turning point in the legal status of water, as it closed any possibility of private ownership over natural sources of water rights. This law was in effect until 2004, when the National Congress updated it to align with the 1998 constitutional norm, as well as with the law on state modernization, which sought greater private sector involvement. In 2008, deeply promoted by indigenous groups and its worldviews, Ecuador produced a new constitution established in Article 71, quote, "Nature for Pachamama, where life reproduces and is realized, has the right to have its existence, maintenance, and regeneration of its vital cycles, structure, functions, and evolutionary processes respected. Every person, community, people, or nationality may demand from public authorities the fulfillment of nature's rights." End of quote. In 2014, with the intention of aligning water regulation with the Constitution, the Organic Law of Water Resources was enacted. However, it was declared unconstitutional on January 28, 2020, because the parliamentary process for producing the law did not include prior consultation with ethnic communities regarding the 169 OIT Convention. To avoid the state of legal uncertainty, the Constitutional Court stated that the judge's decision had deferred effects, while Congress may produce a new water law. Discussions on the new regulation were suspended with the recent dissolution of the National Assembly invoked by President Lasso. Hence, this law remains. However, Ecuador has pioneered a novel approach to freshwater ecosystem conservation by establishing water protection areas which prioritize local communities' involvement as part of the ecosystem. This innovative strategy, grounded in the nation's constitution, tries to prioritize the protection of water resources. It fosters active community engagement, recognizes the inherent rights of nature. It's not coincidental that the view of Ecuadorian, Bolivian, or Colombian ethnic groups have been protagonists in the justification for granting rights to rivers. If one considers a society's relationship with water from a pre-modern perspective, for example, it appears clear. A pre-Columbian community might say, "The river is my home." Centuries later, a pre-industrial community may say, "The river provides me with drinking water, fish, and power to run a mill." Finally, a contemporary society whose relationship with the river has been partially broken and is entirely mediated will drink the river's water that arrives to their home, use the energy produced by a dam, and would likely not know or even wonder where the water they drink or the energy they use comes from. Water becomes predominantly and almost exclusively a resource. However, in Ecuador, despite some advancements, the prevalence of outdated regulations have resulted in a fragmented water law characterized by inconsistencies and inefficacy. Years after, the rights of nature, in the strictest sense, remain undeveloped. A recent state-sponsored research has revealed a modest level of water security within the country, both in terms of environmental health and domestic supply. Chile, the model of water privacy. Chile is characterized by marked hydrological heterogeneity, reflecting at least two distinct conditions. First, significant variations in distribution of water resources. Second, from a management perspective, water demand is concentrated in regions with lower availability, leading to conflicts and imbalances. between water-intensive sectors such as agriculture and mining and the urban consumption. In northern Chile, the shaping of water landscapes, where infrastructure plays a central role directing spatial and economic trajectories, reflects the tension between the supply of suitable soil and climatic conditions for agricultural production and the water scarcity that is a structural characteristic of Chile's arid and semi-arid zones. Since pre-Columbian times, access to water in northern Chile has been the primary determinant of land ownership patterns and productivity. The region's development has been heavily reliant on the construction and operation of infrastructure. Furthermore, in addition to agriculture and livestock farming, mining has been a significant economic activity. The norms of the civil code and Chilean jurisprudence effectively classified water as a private property due to three specific conditions. First, the existence of private water ownerships prior to the code's enactment. Second, the provision that states that properties bordering water bodies will be irrigated. And the principle that water introduced into artificial channels belonged to the channel's constructor. This is the case for general norms that have a restricted application in specific spaces, meaning they admit or legalize particular situations in which there is a meaning of water inherently related to property. This is the context in which the 1981 Chilean Water Code must be interpreted, a problem to the state, an expression and development of the 1980 political constitution, its economic focus. As such, it is not directly related to the integrated water resources management approach or the doubling principles, but rather to the explicit objective proposing an approach geared towards recognizing water as a market commodity, which is subject to appropriation according to the principles and rules of private property. Among the defenders of the Chilean model, there is the idea, for example, that the allocation system based on the market of water rights presents significant economic benefits as it considers water as an economic good, internalizing its scarcity price. Although some advantages of the Chilean model can be recognized, these are intimately related to structural problems. The water market's creation excludes uses that are elusive to economic valuation, namely ecosystem and cultural uses. Furthermore, the country's water supply relies on data obtained from records of precipitation levels, as there are no strict methodologies to measure effective water extraction. The government has employed water usage rights as the standard measurement. As an effect, it has led to the idea that access to water is only possible through private titles and market mechanisms. This discussion has been updated and it becomes increasingly urgent in the margins of the most relevant fact among which this research takes place. The recent social outburst, which opened the discussion of modifying the Constitution. One of the proposals is to include in the Constitution, in the Chilean Constitution, the following article, quote, "Nature has the right to have its existence respected and protected, to regeneration, to maintenance, and to restoration." Up to now, however, the Chilean legal framework has not successfully integrated broader approaches regarding ecosystem and communities. Conclusions. In the year 2000, the Conference of the Parties, the Convention on Biological Diversity, CBD, established in its declaration the need to implement a systematic approach to the protection of biological diversity. The ecosystem approach is then a holistic strategy for managing low water and biodiversity that prioritizes conservation, sustainable use, and equitable benefit sharing. It is grounded in scientific principles, acknowledging the interconnectedness of organisms and their environment, including humans. In contrast, the legislation of the three studied conferences until the end of the 20th century was rooted in utilitarian conservation and state simplification, aiming to regulate water both exclusively as a resource for human consumption. Such regulations are still in force in all three states, and therefore, despite commendable efforts as granted rights to rivers and nature or developing the ecosystem approach, these newer norms have been challenging to implement systematically. Consequently, a coherent framework. Furthermore, the scientific knowledge and technology, both indispensable for adequate regulatory decision-making, remain limited in all three cases. Knowledge about aquatic ecosystems and their biodiversity still needs to be developed. It is not possible to regulate and manage ecosystems that are unknown in a technical sense. Lastly, the political instability faced by the three states, as well as scenarios of armed conflict and communities broken by distrust and violence, make it difficult for norms to be enforced. To varying degrees, yes, but in all three cases, a common denominator may be the fact that there is a certain distance between water law and aquatic ecosystems reality. It is also feasible to interrogate the efficacy of granting rights to nature, given the substantial challenges inherent in its practical implementation. What the norms state is one thing, and what actually happens is quite another. Rivers too frequently have carried the liveliness towards to flow upon the currents. Thank you so much.
Dieser Podcast wurde finanziert von der Europäischen Union. Bis zum nächsten Mal. This podcast was financed by the European Union. Take care.